Question 1. Quality control measures reveal that a firearms instructor is advising a client who holds a valid concealed handgun permit from North Carolina on how to legally carry a concealed handgun in Virginia. The instructor suggests that the client can simply carry their handgun concealed in Virginia as long as their North Carolina permit is current, without needing to check Virginia's specific regulations for non-residents. What is the most appropriate course of action for the instructor to ensure regulatory compliance for their client in Virginia? Option A. Provide the client with information on Virginia's concealed handgun permit requirements based on the instructor's past experience, assuming the laws have not significantly changed. Option B. Inform the client that their North Carolina concealed handgun permit is sufficient for carrying a concealed handgun in Virginia due to general interstate firearm recognition laws. Option C. Recommend that the client rely on federal laws regarding firearm transportation, as these generally allow for carrying firearms across state lines with a valid permit. Option D. Advise the client to proactively verify Virginia's current reciprocity agreements with North Carolina and ensure the client meets all Virginia requirements for non-resident permit holders, including any specific documentation or notification procedures. Correct answer is D. Advise the client to proactively verify Virginia's current reciprocity agreements with North Carolina and ensure the client meets all Virginia requirements for non-resident permit holders, including any specific documentation or notification procedures. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a permit holder to navigate the complexities of interstate recognition of concealed handgun permits, specifically concerning Virginia's reciprocity agreements. Misinterpreting or failing to adhere to the specific requirements of Virginia's non-resident concealed handgun permit regulations can lead to serious legal consequences, including permit revocation and criminal charges. The core challenge lies in understanding the nuances of Virginia law regarding out-of-state permit holders and their obligations when carrying a concealed handgun within the Commonwealth. Correct approach analysis. The best professional practice involves proactively verifying Virginia's current reciprocity agreements with the applicant's home state and ensuring the applicant meets all Virginia residency and permit requirements. This approach is correct because Virginia Code Section 18.2-308.010a outlines the conditions under which a non-resident may obtain a concealed handgun permit, and Section 18.2-308.010b addresses reciprocity. A thorough verification process ensures compliance with both the initial permit issuance criteria and the ongoing obligations of carrying a concealed handgun in Virginia, respecting the Commonwealth's specific legal framework for non-residents. Incorrect approaches analysis. One incorrect approach involves assuming that a valid concealed handgun permit from another state automatically grants the right to carry a concealed handgun in Virginia without further verification. This fails to acknowledge that Virginia's reciprocity is not automatic for all states and requires specific agreements or recognition, as outlined in Virginia Code Section 18.2-308.010b. Relying solely on the out-of-state permit without confirming Virginia's acceptance constitutes a significant regulatory failure. Another incorrect approach is to advise the applicant to rely on general federal laws regarding firearm transportation, such as the Firearm Owners Protection Act, FOPA, without considering Virginia's specific concealed carry permit requirements for non-residents. While FOPA addresses transportation, it does not supersede state laws regarding the carrying of concealed handguns, especially when a permit is required. This approach ignores the direct mandate of Virginia's concealed handgun permit laws for non-residents. A further incorrect approach is to provide advice based on outdated information regarding Virginia's reciprocity agreements. Virginia's laws and agreements can change, and relying on past knowledge without current verification can lead to non-compliance. This demonstrates a failure to maintain up-to-date knowledge of the relevant regulatory framework, which is a critical ethical and professional obligation. Professional reasoning. Professionals should adopt a systematic approach to advising clients on concealed handgun permit matters. This involves 1. Identifying the specific jurisdiction's laws, in this case, Virginia. 2. Determining the applicant's residency and permit status in their home state. 3. Researching the target jurisdictions, Virginia's specific laws regarding non-resident permits and reciprocity agreements. 4. verifying the current status of any relevant reciprocity agreements directly with the issuing authority or through official state resources. 5. Advising the client based on confirmed, up-to-date legal requirements, emphasizing the importance of compliance with all applicable laws. Question 2. The monitoring system demonstrates that a firearms dealer in Virginia has received an application for a non-resident concealed handgun permit from an individual who recently relocated to Virginia and states they intend to reside there permanently, but has not yet updated their driver's license or voter registration to reflect their new Virginia address. What is the most appropriate regulatory compliance approach for the dealer to take? Option A. Advise the applicant to complete the non-resident application by stating their previous out-of-state address as their current residence, as they have not yet officially changed their residency documentation. Option B. Refuse to process any application from an individual who has recently moved to Virginia, as they are presumed to be establishing residency and therefore ineligible for a non-resident permit. Option C. Inform the applicant that based on their stated intent to reside in Virginia, they are likely no longer eligible for a non-resident permit and must apply for a Virginia resident concealed handgun permit once they meet the established residency requirements, or provide proof of their continued primary domicile outside of Virginia. Option D. Process the application as a non-resident permit because the applicant has indicated they are applying as a non-resident, regardless of their recent relocation to Virginia. The correct answer is C. Inform the applicant that based on their stated intent to reside in Virginia, they are likely no longer eligible for a non-resident permit and must apply for a Virginia resident concealed handgun permit once they meet the established residency requirements, or provide proof of their continued primary domicile outside of Virginia. Explanation. Scenario analysis. This scenario presents a professional challenge for a Virginia licensed firearms dealer who has received an application for a non-resident concealed handgun permit from an individual who has recently moved to Virginia but has not yet established residency for the purpose of obtaining a Virginia permit. The challenge lies in accurately interpreting and applying Virginia's specific residency requirements for non-resident permit applications, balancing the applicant's stated intent with the legal definitions of residency, and ensuring compliance with the Virginia Firearms Transaction Program and related statutes to avoid facilitating an illegal transfer or permit issuance. Correct approach analysis. The best professional practice involves verifying the applicant's current Virginia residency status against the criteria outlined in the Code of Virginia, specifically Section 18-2-308-01, which governs concealed handgun permits for non-residents. This approach requires the dealer to understand that a non-resident permit is intended for individuals who maintain their primary residence outside of Virginia, but have a specific need to carry a concealed handgun within the Commonwealth. If the applicant has moved to Virginia with the intent to reside there, they are no longer eligible for a non-resident permit and must apply for a resident permit, which has different application procedures and requirements. The dealer must politely inform the applicant of this distinction and advise them to apply for a resident permit once they meet the established residency criteria, or to proceed with the non-resident application if they can demonstrate their primary domicile remains outside Virginia. This ensures adherence to the law and prevents the applicant from improperly obtaining a permit. Incorrect approaches analysis. One incorrect approach is to accept the application at face value and process it as a non-resident permit simply because the applicant states they are applying as a non-resident, without further inquiry into their actual residency status in Virginia. This fails to comply with the spirit and letter of Virginia law, which defines who is eligible for a non-resident permit. Another incorrect approach is to refuse to process any application from someone who has recently moved to Virginia, regardless of their stated intent or ability to prove out-of-state residency. This is overly restrictive and does not align with the provisions for non-resident permits. Finally, advising the applicant to simply lie about their residency on the application is a severe ethical and legal violation, exposing both the applicant and the dealer to significant penalties. Professional reasoning. Professionals in this situation must adopt a framework of diligent inquiry and strict adherence to regulatory definitions. First, understand the specific legal definition of residency as it pertains to concealed handgun permits in Virginia. Second, engage the applicant in a professional and informative manner to clarify their residency status. Third, apply the relevant Virginia statutes, Section 18, 2-308, 01, and any related definitions of residency to the applicant's stated circumstances. Fourth, clearly communicate the legal requirements and options to the applicant, guiding them towards the correct application process based on their verified residency. This process prioritizes legal compliance and ethical conduct over expediency or assumption. Question 3. Stakeholder feedback indicates that applicants for a Virginia non-resident concealed handgun permit are sometimes unclear about the validity of their out-of-state training. Considering Virginia's regulatory framework, which approach best ensures a compliant and successful application? Option A. Verifying that the applicant's out-of-state handgun training meets the specific requirements outlined in Virginia Code Section 18, 2-308, 02 for concealed handgun permit issuance, and confirming Virginia's current reciprocity agreements with the applicant's home state. Option B. Relying on the fact that the applicant already possesses a concealed handgun permit from their home state, believing this implies their training is sufficient for Virginia. Option C. Assuming that any handgun training completed for a concealed handgun permit in another state is automatically acceptable for a Virginia permit due to reciprocity. Option D. Submitting the application with the out-of-state training certificate and hoping it will be accepted by the Virginia State Police without prior verification. The correct answer is A. Verifying that the applicant's out-of-state handgun training meets the specific requirements outlined in Virginia Code Section 18, 2-308, 02 for concealed handgun permit issuance, and confirming Virginia's current reciprocity agreements with the applicant's home state. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a Virginia non-resident concealed handgun permit applicant to navigate the specific reciprocity and recognition laws of Virginia, which can be complex and subject to change. Misinterpreting these laws can lead to an invalid permit application or, worse, legal consequences for the applicant. Careful judgment is required to ensure all Virginia-specific requirements are met, particularly concerning out-of-state training and permit validity. Correct approach analysis. The best professional practice involves thoroughly researching Virginia's current laws and regulations pertaining to non-resident concealed handgun permits, specifically focusing on the requirements for out-of-state training equivalency and the process for submitting an application. This approach ensures that the applicant's training and documentation meet Virginia's exact standards, thereby maximizing the likelihood of a successful and legally compliant application. Virginia Code Section 18, 2-308, 02 outlines the requirements for issuing concealed handgun permits, including provisions for non-residents and the recognition of training from other states. Adhering strictly to these codified requirements is paramount. Incorrect approach is analysis. Relying solely on the training received for a permit in another state without verifying its acceptance or equivalency in Virginia is a significant regulatory failure. Virginia has specific criteria for what constitutes acceptable handgun training for permit issuance, and simply having a permit from another state does not automatically validate that training for Virginia purposes. Furthermore, assuming that permit from a neighboring state automatically grants reciprocity without confirming Virginia's specific reciprocity agreements is a violation of regulatory compliance. Virginia's recognition of out-of-state permits is governed by specific statutes and executive orders, not by assumption. Finally, submitting an application without confirming that the applicant meets all Virginia residency or non-residency requirements, as defined by Virginia law, is a procedural error that would lead to rejection. Professional reasoning. Professionals assisting applicants for Virginia non-resident concealed handgun permits must adopt a systematic approach. This begins with identifying the applicant's current state of residence and the jurisdiction for which the permit is sought, Virginia. The next step is to consult the most current Virginia statutes and regulations governing concealed handgun permits, paying close attention to sections addressing non-residents and the acceptance of out-of-state training and permits. Any assumptions about reciprocity or training equivalency must be rigorously verified against these official sources. If any doubt exists, direct consultation with the Virginia State Police or legal counsel specializing in firearms law is advisable. The guiding principle is strict adherence to the letter of the law in the jurisdiction where the permit is sought. Question 4. Operational review demonstrates that a Virginia resident is seeking to obtain a non-resident concealed handgun permit in the state of North Carolina. Which of the following approaches best ensures compliance with North Carolina's regulatory framework for issuing such permits? Option A. Assume that Virginia's concealed handgun permit laws and application process are sufficient for obtaining a permit in North Carolina due to reciprocity. Option B. Submit an application to North Carolina that only includes information relevant to Virginia's concealed handgun permit requirements, omitting any details not explicitly requested by Virginia. Option C. Thoroughly research North Carolina's specific concealed handgun permit laws for non-residents, including eligibility criteria, required documentation, and application procedures, and then meticulously complete the North Carolina application accordingly. Option D. Provide incomplete information on the North Carolina application, believing that the information not provided is not material to their Virginia permit. The correct answer is C. Thoroughly research North Carolina's specific concealed handgun permit laws for non-residents, including eligibility criteria, required documentation, and application procedures, and then meticulously complete the North Carolina application accordingly. Explanation. Scenario analysis. This scenario presents a professional challenge for a Virginia resident applying for a non-resident concealed handgun permit in another state. The core difficulty lies in navigating the differing legal requirements and application processes of two distinct jurisdictions, specifically Virginia and the target state. Misunderstanding or misrepresenting information on the application, even unintentionally, can lead to denial of the permit, potential legal repercussions, and damage to the applicant's reputation. Careful judgment is required to ensure absolute compliance with all applicable laws and regulations of both states. Correct approach analysis. The best professional practice involves thoroughly researching and understanding the specific concealed handgun permit laws and application requirements of the state where the permit is being sought. This includes identifying any reciprocity agreements with Virginia, understanding the eligibility criteria, the required documentation, the application submission process, and any specific training or background check mandates of the target state. The applicant must then meticulously complete the application, providing truthful and accurate information that aligns with the target state's requirements, and ensuring all supporting documents are correctly submitted. This approach is correct because it prioritizes direct compliance with the laws of the jurisdiction where the permit is being requested, which is the primary legal authority governing the issuance of the permit. It avoids assumptions and ensures all necessary steps are taken to meet the specific legal standards of that state. Incorrect approach is analysis. One incorrect approach is to assume that Virginia's concealed handgun permit laws are sufficient for obtaining a permit in another state without further investigation. This is professionally unacceptable because each state has its own sovereign authority to regulate the carrying of concealed handguns within its borders. Relying solely on Virginia's regulations ignores the specific legal framework of the target state, which may have stricter requirements, different disqualifying factors, or a distinct application process. Another incorrect approach is to submit an application to the target state that only includes information relevant to Virginia's requirements, omitting details or documentation specifically requested by the target state. This is a regulatory failure because it demonstrates a lack of due diligence and a failure to adhere to the explicit instructions and legal mandates of the permitting authority. The application must be tailored to the requirements of the state where it is being filed. A further incorrect approach is to provide incomplete or misleading information on the application, even if the applicant believes it is not material to their Virginia permit. This is ethically and legally problematic. All information provided on a permit application is subject to verification, and any misrepresentation, intentional or otherwise, can lead to denial and potential criminal charges. The obligation is to be truthful and complete according to the requirements of the applying jurisdiction. Professional reasoning. Professionals facing this situation should employ a systematic decision-making process. First, identify the specific jurisdiction whose permit is being sought. Second, conduct thorough research into that jurisdiction's laws and regulations pertaining to concealed handgun permits, paying close attention to any specific requirements for non-residents and reciprocity with the applicant's home state. Third, meticulously gather all required documentation and information as stipulated by the target jurisdiction. Fourth, Complete the application with absolute accuracy and truthfulness, ensuring all fields are addressed according to the instructions. Finally, submit the application through the designated channels and await the decision, prepared to provide any further clarification or documentation if requested. This structured approach ensures compliance and minimizes the risk of denial or legal complications. Question 5. The assessment process reveals an applicant for a Virginia non-resident concealed handgun permit has a prior conviction for a misdemeanor offense that occurred several years ago. The applicant believes this conviction is not a disqualifier under Virginia law and has submitted their application accordingly. What is the most appropriate course of action for the licensing authority to ensure compliance with Virginia's regulatory framework for concealed handgun permits? Option A. Deny the permit application outright based on the presence of any prior misdemeanor conviction, regardless of its nature or the specific provisions of Virginia law. Option B. Request that the applicant obtain a legal opinion from their own attorney confirming the conviction is not disqualifying before the licensing authority will consider the application. Option C. Accept the applicant's assertion that the misdemeanor conviction is not disqualifying and proceed with processing the permit application without further investigation into the conviction specifics. Option D. Conduct a thorough review of the applicant's criminal history, comparing the specific misdemeanor conviction against the disqualifying offenses listed in Virginia Code Section 18-2-308-09 and related statutes, and submit all findings to the Superintendent of the Virginia State Police for a determination. The correct answer is D. Conduct a thorough review of the applicant's criminal history, comparing the specific misdemeanor conviction against the disqualifying offenses listed in Virginia Code Section 18-2-308-09 and related statutes, and submit all findings to the Superintendent of the Virginia State Police for a determination. Explanation. The assessment process reveals a scenario where an applicant for a Virginia non-resident concealed handgun permit has a past conviction that may impact their eligibility. This situation is professionally challenging because it requires a nuanced understanding of Virginia's specific laws regarding firearm permits, particularly concerning the definition of disqualifying offenses and the discretion afforded to the Superintendent of the Virginia State Police. The applicant's interpretation of their past convictions' impact, while potentially sincere, may not align with the legal standards. Careful judgment is required to ensure compliance with Virginia Code Section 18-2-308-09 and related statutes, balancing the applicant's rights with public safety concerns. The best professional approach involves a thorough review of the applicant's criminal history against the specific disqualifying criteria outlined in Virginia law. This includes understanding what constitutes a felony conviction, a conviction for a misdemeanor crime of domestic violence, or any other offense that Virginia law explicitly prohibits for permit holders. The applicant must provide all necessary documentation, including certified court records, to allow for an accurate assessment. The Superintendent of the Virginia State Police has the authority to grant or deny permits based on these records and the applicant's overall suitability. Therefore, the correct approach is to meticulously gather and present all relevant information to the superintendent for a definitive determination based on the established legal framework. An incorrect approach would be to rely solely on the applicant's personal interpretation of their conviction's impact, especially if that interpretation suggests the conviction is not disqualifying without a formal legal review. This fails to acknowledge the superintendent's ultimate authority and the specific legal definitions of disqualifying offenses. Another incorrect approach is to assume that any past conviction, regardless of its nature or the sentence imposed, automatically disqualifies an applicant without consulting the precise language of Virginia Code Section 18-2-308-09. This demonstrates a lack of understanding of the statutory nuances. Finally, submitting an incomplete application or withholding relevant information about the conviction, even if the applicant believes it is minor, is a critical failure. This not only violates the application requirements, but also prevents the superintendent from making an informed decision, potentially leading to denial and undermining the integrity of the permitting process. Professionals should employ a decision-making framework that prioritizes adherence to the specific statutory requirements of Virginia's concealed handgun permit laws. This involves 1. identifying the relevant Virginia Code sections governing non-resident permits and disqualifying offenses. 2. Thoroughly investigating the applicant's criminal history, obtaining certified records. 3. Comparing the applicant's history against the explicit disqualifiers in the law. 4. Presenting all findings and documentation to the superintendent of the Virginia State Police for their statutory review and decision. 5. Maintaining transparency and accuracy throughout the process. Question 6. The audit findings indicate that a Virginia licensed firearms dealer has processed an application for a non-resident concealed handgun permit. The applicant, a resident of North Carolina, provided a certificate of completion for a firearms safety course taken in North Carolina and stated they possess a valid North Carolina concealed handgun permit. What is the most compliant and professionally responsible course of action for the Virginia dealer to take regarding the verification and submission of this application? Option A. Advise the applicant that their North Carolina concealed handgun permit is sufficient on its own and that no further training verification is necessary for a Virginia non-resident permit. Then submit the application. Option B. Accept the North Carolina Firearms Safety Course certificate and the North Carolina concealed handgun permit at face value, assuming they automatically satisfy Virginia's requirements, and proceed with submitting the application to the Virginia State Police. Option C. Inform the applicant that Virginia does not issue non-resident concealed handgun permits and that they must obtain a permit from their state of residence without further inquiry into their qualifications or the application process. Option D. Verify that the North Carolina Firearms Safety Course meets the training requirements specified in Virginia Code Section 18.2-308. 02. Confirm the applicant's valid North Carolina concealed handgun permit and then submit the complete application package, including all required documentation and fees, to the Virginia State Police. Correct answer is D. Verify that the North Carolina Firearms Safety Course meets the training requirements specified in Virginia Code Section 18.2-308. 02. Confirm the applicant's valid North Carolina concealed handgun permit, and then submit the complete application package, including all required documentation and fees, to the Virginia State Police. Explanation. Scenario analysis. This scenario presents a professional challenge for a Virginia licensed firearms dealer who has received an application for a non-resident concealed handgun permit. The challenge lies in ensuring strict adherence to Virginia's specific statutory requirements for processing such applications, particularly concerning the verification of out-of-state applicant qualifications and the dealer's role in the submission process. Failure to comply can result in significant penalties, including fines and potential revocation of the dealer's license, and could also compromise the integrity of the permitting system. Correct approach analysis. The best professional practice involves meticulously verifying that the applicant has met all the specific training and qualification requirements as mandated by Virginia Code Section 18.2-308. 02 for non-residents. This includes confirming that the applicant's out-of-state firearms safety or training course is equivalent to Virginia's requirements, and that the applicant possesses a valid concealed handgun permit or equivalent from their state of residence, if applicable, or has otherwise demonstrated proficiency as required by Virginia law. The dealer must then ensure the application, along with all required documentation and fees, is submitted to the appropriate Virginia State Police Authority within the statutory timeframe. This approach is correct because it directly aligns with the explicit mandates of Virginia law concerning the processing of non-resident concealed handgun permit applications, ensuring all legal prerequisites are met before submission. Incorrect approach is analysis. One incorrect approach would be to accept the application based solely on the applicant's assertion that they have completed a firearms safety course in their home state, without independently verifying its equivalence to Virginia's standards or confirming the applicant's eligibility under Virginia Code Section 18.2-308. 02. This is a regulatory failure because Virginia law requires specific verification of training and qualifications, not mere self-attestation. Another incorrect approach would be to submit the application to the Virginia State Police without ensuring all required supporting documents, such as proof of training and any necessary out-of-state permit information, are included and properly formatted according to Virginia's procedural guidelines. This constitutes a procedural failure, as incomplete applications are subject to rejection and can lead to delays or denial of the permit, and it bypasses the dealer's responsibility to facilitate a complete and compliant submission. A third incorrect approach would be to advise the applicant that their out-of-state permit automatically qualifies them for a Virginia non-resident permit, without confirming if their home state's permit meets Virginia's specific reciprocity or qualification standards as outlined in the Code of Virginia. This is a misinterpretation of reciprocity laws and a failure to adhere to the specific requirements for non-resident permits. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes strict adherence to the governing statutes. This involves 1. Thoroughly understanding the specific requirements of Virginia Code Section 18.2-308.02 for non-resident concealed handgun permits, paying close attention to training, qualification, and documentation mandates. 2. Implementing a robust internal verification process to confirm that all applicant-provided documentation meets or exceeds Virginia's legal standards. 3. Consulting official Virginia State Police guidance or legal counsel if any ambiguity exists regarding the interpretation of the law or the acceptability of out-of-state credentials. 4. Ensuring timely and complete submission of all compliant applications and supporting materials to the designated state authority. This systematic approach minimizes risk and upholds the integrity of the permitting process. Question 7. Operational review demonstrates that an applicant for a Virginia non-resident concealed handgun permit resides in a state that does not have a formal reciprocity agreement with Virginia. The applicant possesses a valid driver's license from their home state and states they are a responsible citizen who needs the permit for personal protection. Which of the following approaches best ensures compliance with Virginia's regulatory framework for non-resident concealed handgun permits? Option A. Process the application solely based on the applicant's assertion of needing the permit for self-defense, without further verification of their home state's licensing status or reciprocity. Option B. Accept the applicant's self-declaration of being a responsible citizen and their stated need for personal protection as sufficient grounds for permit issuance. Option C. Verify that the applicant's home state issues concealed handgun permits to its residents and confirm if Virginia has a reciprocity agreement with that state, or if the applicant meets Virginia's independent criteria for non-resident permits. Option D. Issue the permit based on the applicant's valid driver's license from their home state, assuming it implies eligibility. Correct answer is C. Verify that the applicant's home state issues concealed handgun permits to its residents and confirm if Virginia has a reciprocity agreement with that state, or if the applicant meets Virginia's independent criteria for non-resident permits. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a thorough understanding of Virginia's specific requirements for non-resident concealed handgun permits, particularly concerning the reciprocity agreements and the applicant's home state licensing status. Misinterpreting these requirements can lead to the denial of a legitimate application or, worse, the issuance of a permit to an individual who does not meet the necessary qualifications, potentially compromising public safety and violating state law. Careful judgment is required to ensure compliance with Virginia Code Section 18.2-308.010 et seq. Correct approach analysis. The best professional practice involves verifying that the applicant's home state issues concealed handgun permits to its own residents, and that Virginia has a reciprocity agreement with that state, or that the applicant meets Virginia's criteria for non-resident permits independently. This approach directly addresses the core of Virginia's non-resident permit requirements, which are predicated on the applicant's ability to legally carry a concealed handgun in their home jurisdiction, and the established legal framework between Virginia and that jurisdiction. This ensures that the applicant is not only compliant with Virginia law, but also with the laws of their primary residence, aligning with the intent of the reciprocity provisions. Incorrect approaches analysis. One incorrect approach is to assume that simply possessing a valid driver's license from another state automatically qualifies an applicant for a Virginia non-resident concealed handgun permit. Virginia law specifically requires the applicant's home state to issue concealed handgun permits to its residents and to have a reciprocity agreement with Virginia, or for the applicant to meet Virginia's independent criteria. A driver's license alone does not fulfill these specific licensing requirements. Another incorrect approach is to process the application solely based on the applicant's assertion that they are a responsible citizen, without independently verifying their home state's permit status and Virginia's reciprocity. Virginia law mandates specific checks and balances to ensure that non-residents meet the same standards as Virginia residents, or that their home state's licensing process is recognized. This approach bypasses crucial legal safeguards. A further incorrect approach is to grant the permit based on the applicant's claim of needing the permit for self-defense, without confirming the validity of their home state's permit or the existence of a reciprocity agreement. While self-defense is the purpose of obtaining a permit, the legal qualification hinges on the applicant's status in their home state and Virginia's recognition of that status, not solely on their stated need. Professional reasoning. Professionals should approach this situation by first consulting Virginia Code Section 18, 2-308, 010 et sec, and any relevant administrative guidelines from the Virginia State Police. The decision-making process should involve a systematic verification of the applicant's home state's licensing laws and the status of any reciprocity agreement with Virginia. If no reciprocity exists, the applicant must then be assessed against Virginia's independent criteria for non-resident permits. This methodical, legally grounded approach ensures compliance and upholds the integrity of the permitting process. Question 8. The evaluation methodology shows a Virginia resident is seeking to obtain a non-resident concealed handgun permit in North Carolina. Which of the following actions best demonstrates adherence to regulatory compliance and professional responsibility in this situation? Option A. Submitting a copy of their Virginia concealed handgun permit and assuming it will be recognized by North Carolina due to reciprocity, without further investigation. Option B. Thoroughly reviewing North Carolina's official statutes and administrative rules pertaining to concealed handgun permits for non-residents, and meticulously completing their application with all requested information, including any state-specific training requirements. Option C. Relying on advice from an online forum discussing concealed carry permits in North Carolina to complete the application. Option D. Providing only the information required for a Virginia concealed handgun permit application, as they are a Virginia resident. The correct answer is B. Thoroughly reviewing North Carolina's official statutes and administrative rules pertaining to concealed handgun permits for non-residents, and meticulously completing their application with all requested information, including any state-specific training requirements. Explanation. This scenario presents a professional challenge for a Virginia resident applying for a non-resident concealed handgun permit in another state. The core difficulty lies in navigating the differing legal requirements and application processes of two distinct jurisdictions, ensuring full compliance with both Virginia's laws regarding permit issuance and the laws of the state where the permit is sought. Misunderstanding or misrepresenting information can lead to application denial, potential legal repercussions, and a loss of credibility. Careful judgment is required to accurately identify and fulfill all obligations. The correct approach involves diligently researching and adhering to the specific application requirements of the state where the non-resident permit is being sought, while also ensuring continued compliance with Virginia's laws. This includes understanding if the target state has reciprocity agreements with Virginia, if specific training is mandated by that state, which may differ from Virginia's requirements, and if any additional background checks or documentation are necessary. This approach is correct because it prioritizes direct compliance with the laws of the jurisdiction where the permit is being applied for, which is the ultimate authority on permit issuance for its residents and non-residents. It also implicitly acknowledges the applicant's responsibility to maintain compliance with their home state's regulations. An incorrect approach would be to assume that Virginia's concealed handgun permit requirements are universally applicable or sufficient for obtaining a permit in another state. This fails to recognize that each state has its own sovereign authority to regulate firearms within its borders. Another incorrect approach is to provide incomplete or inaccurate information on the application, even if unintentionally. This directly violates the statutory requirements for truthfulness in applications and can lead to severe penalties. Finally, relying solely on information from unofficial sources or personal anecdotes without verifying with the official regulatory bodies of the target state is a risky and unprofessional practice that can lead to significant errors. Professionals should employ a decision-making framework that begins with identifying the specific jurisdiction whose laws are in question. Next, they must proactively seek out the official statutes, regulations, and application forms from that jurisdiction's relevant government agency, e.g., state police, Department of Public Safety. This information should be cross-referenced with any reciprocity agreements or specific requirements for non-residents. Any discrepancies or additional requirements must be addressed thoroughly before submitting an application. Question 9. Cost-benefit analysis shows that obtaining a non-resident concealed handgun permit in another state requires careful consideration of varying legal landscapes. A Virginia resident planning an extended stay in North Carolina wishes to carry a concealed handgun. Which of the following actions best ensures compliance with firearm regulations in North Carolina while respecting Virginia's laws? Option A. Thoroughly research North Carolina's specific laws and application procedures for non-resident concealed handgun permits and apply accordingly, while also being aware of Virginia's reciprocity status. Option B. Assume that Virginia's concealed handgun permit is recognized in North Carolina due to reciprocity and proceed with carrying concealed without further investigation. Option C. Rely on advice from friends who have carried concealed in North Carolina to understand the necessary steps for a Virginia resident. Option D. Focus solely on meeting Virginia's requirements for a concealed handgun permit, believing this automatically satisfies any out-of-state carrying privileges. Correct answer is A. Thoroughly research North Carolina's specific laws and application procedures for non-resident concealed handgun permits and apply accordingly, while also being aware of Virginia's reciprocity status. Explanation. Scenario analysis. This scenario presents a professional challenge for a Virginia resident applying for a non-resident concealed handgun permit in another state. The core difficulty lies in navigating the differing legal requirements and application processes of two distinct jurisdictions, specifically Virginia and the destination state, while ensuring full compliance with both. Misinterpreting or overlooking any requirement could lead to application denial, legal repercussions, or even unintended violations of firearm laws. Careful judgment is required to accurately identify and fulfill all obligations. Correct approach analysis. The best professional practice involves proactively and thoroughly researching the specific concealed handgun permit laws and application procedures of the destination state, in addition to understanding Virginia's requirements for permit holders. This approach is correct because Virginia Code Section 18.2-308.06 outlines the reciprocity agreements Virginia has with other states, but it does not absolve a Virginia resident from complying with the laws of the state where they intend to carry a concealed handgun. Therefore, understanding and adhering to the destination state's laws, including their specific application process, background check requirements, and any training mandates, is paramount for lawful concealed carry. This ensures compliance with the principle of respecting and obeying the laws of the jurisdiction in which one is present. Incorrect approach is analysis. One incorrect approach is to assume that Virginia's concealed handgun permit automatically grants the right to carry concealed in any other state due to reciprocity, without verifying the specific terms of that reciprocity or the destination state's independent requirements. This fails to acknowledge that reciprocity is a mutual agreement, and that each state retains the authority to set its own standards for issuing permits or recognizing permits from other states. This approach risks violating the destination state's laws, which may have stricter requirements or may not recognize Virginia permits under all circumstances. Another incorrect approach is to only focus on the requirements for obtaining a concealed handgun permit in Virginia and believe that fulfilling those is sufficient for carrying in another state. This overlooks the fundamental principle that when you are in a different jurisdiction, you are subject to its laws. Virginia's laws govern the issuance and renewal of its permits, but they do not dictate how other states must treat those permits for the purpose of concealed carry within their borders. A third incorrect approach is to rely solely on informal advice from friends or online forums regarding the permit requirements of the destination state. While these sources might offer some guidance, they are not authoritative and can be outdated or inaccurate. Legal requirements for firearm permits are precise and can change. Relying on such information without official verification can lead to significant legal missteps and non-compliance with the destination state statutes. Professional reasoning. Professionals facing this situation should employ a systematic approach. First, identify the specific destination state. Second, consult the official government website or legislative statutes of that destination state to understand their laws regarding concealed handgun permits for non-residents. This includes researching application procedures, eligibility criteria, required documentation, training requirements, and reciprocity with Virginia. Third, compare these requirements with Virginia's laws to identify any discrepancies or additional steps needed. Finally, meticulously follow the application process of the destination state, ensuring all documentation is accurate and submitted correctly. This methodical process prioritizes legal compliance and minimizes the risk of errors. Question 10. Implementation of a Virginia non-resident concealed handgun permit application requires an applicant to budget for all associated costs. If the Virginia permit fee is $100, and the applicant anticipates a fingerprinting service fee of $25, what is the minimum total amount the applicant should prepare to submit to ensure full compliance with the financial requirements for their application? Option A, $100, Option B, $115, Option C, $150, Option D, $125. The correct answer is D, $125. Explanation. This scenario is professionally challenging because it requires a non-resident applicant to navigate the specific financial requirements for obtaining a Virginia non-resident concealed handgun permit, which involves understanding the interplay between application fees, fingerprinting costs, and potential background check fees, all while ensuring compliance with Virginia Code Section 18.2-308.06. The applicant must accurately calculate the total expenditure to avoid submitting an incomplete application, which could lead to delays or denial. Careful judgment is required to ensure all mandated fees are accounted for and paid correctly. The best professional practice involves accurately calculating the total cost based on the statutory fees. This approach is correct because it directly adheres to the financial obligations outlined in Virginia law for obtaining a non-resident permit. Specifically, Virginia Code Section 18.2-308.06 mandates a permit fee of $100. Additionally, the applicant is responsible for the cost of fingerprinting, which is typically a separate fee charged by the vendor providing the service. While the exact fingerprinting fee can vary by vendor, it is a necessary component of the application process. Therefore, the correct calculation must include the permit fee and an estimated or actual fingerprinting cost. An approach that fails to account for the fingerprinting fee is professionally unacceptable. This is because Virginia Code Section 18.2-308.06 implicitly requires the applicant to bear all costs associated with the application process, including those necessary for background checks and identification, such as fingerprinting. Omitting this cost would result in an incomplete financial submission, violating the spirit and letter of the law by not fulfilling all financial prerequisites for the permit. Another professionally unacceptable approach is to only budget for the permit fee without considering any additional administrative or processing costs. This overlooks the practical realities of the application process, where third-party services like fingerprinting are often mandatory and incur separate charges. Such an approach demonstrates a lack of due diligence in understanding the full financial commitment required by the Commonwealth of Virginia. A flawed approach that involves guessing at the total cost without consulting official sources or understanding the fee structure is also professionally unacceptable. This can lead to underpayment, resulting in application rejection, or overpayment, which is inefficient. The law expects applicants to be diligent in meeting its requirements. The professional decision-making process for similar situations should involve 1. Identifying all statutory fees and requirements mandated by the relevant jurisdiction's laws, in this case, Virginia Code Section 18.2-308.06. 2. Researching any associated costs for mandatory ancillary services, such as fingerprinting, from official or reputable sources. 3. Performing a precise calculation of the total financial obligation. 4. Ensuring the calculated amount is submitted with the application. 5. Consulting official government websites or contacting the issuing authority for clarification if any ambiguity exists regarding fees. Question 11. To address the challenge of obtaining a non-resident concealed handgun permit in another state, a Virginia resident is preparing their application. Which of the following actions best reflects a professional and compliant approach to navigating the application process in the destination state? Option A. Relying on advice from an online firearm enthusiast forum to determine the necessary steps for obtaining a non-resident permit in the destination state. Option B. Assuming that the Virginia concealed handgun permit is automatically recognized in the destination state and therefore no separate application is necessary. Option C. Thoroughly researching the specific application requirements, necessary documentation, fees, and reciprocity agreements for a non-resident concealed handgun permit in the destination state, and submitting a complete and accurate application based on this official information. Option D. Submitting a Virginia concealed handgun permit application form to the destination state, believing it to be universally accepted. The correct answer is C. Thoroughly researching the specific application requirements, necessary documentation, fees, and reciprocity agreements for a non-resident concealed handgun permit in the destination state, and submitting a complete and accurate application based on this official information. Explanation. Scenario analysis. This scenario presents a professional challenge for a Virginia resident applying for a non-resident concealed handgun permit in another state. The core difficulty lies in navigating potentially differing application requirements, background check procedures, and reciprocity agreements between Virginia and the destination state. Misinterpreting or failing to adhere to the specific requirements of the non-resident permit application can lead to denial, legal complications, and potential firearm-related offenses. Careful judgment is required to ensure full compliance with both Virginia's laws regarding permit holders and the laws of the state where the permit is being sought. Correct approach analysis. The best professional practice involves proactively researching and understanding the specific application requirements for a non-resident concealed handgun permit in the target state. This includes identifying the correct application form, understanding the required documentation, such as proof of residency in Virginia, fingerprints, passport-style photos, and any specific training certifications, and determining the appropriate fee structure. Crucially, it necessitates verifying if the target state has a reciprocity agreement with Virginia, which might simplify the process or have specific implications for permit issuance. This approach ensures that the applicant provides all necessary information accurately and completely, minimizing the risk of denial due to procedural errors or incomplete submissions, and directly addresses the legal framework governing concealed handgun permits for non-residents. Incorrect approaches analysis. One incorrect approach is to assume that Virginia's concealed handgun permit laws are sufficient, and that a separate permit is not needed in the other state, or that the Virginia permit will be automatically recognized without any application process. This fails to acknowledge that each state has its own sovereign authority to regulate firearms within its borders, and non-resident permits are often subject to specific application and approval processes. This approach risks violating the firearm laws of the destination state. Another incorrect approach is to submit an incomplete application to the target state, perhaps omitting required supporting documents or failing to disclose relevant information on the application form. This could stem from a misunderstanding of the application scope or a belief that certain information is not pertinent. Such omissions can lead to application denial and may even be considered misrepresentation, carrying further legal consequences. A further incorrect approach is to rely solely on informal advice from friends or online forums regarding the application process, without verifying the information with official sources from the target state's law enforcement or licensing agency. While anecdotal information can sometimes be helpful, it is not a substitute for official guidance and can be outdated or inaccurate, leading to significant procedural errors. Professional reasoning. Professionals facing this situation should adopt a systematic and diligent approach. The primary step is to identify the official licensing authority in the state where the non-resident permit is sought. This authority will provide the most accurate and up-to-date information regarding application procedures, required documentation, fees, and any relevant laws or reciprocity agreements. Applicants should then meticulously review all provided materials, complete the application form truthfully and thoroughly, and ensure all supporting documents are included and correctly formatted. Finally, maintaining copies of all submitted documents and tracking the application's progress is essential for professional due diligence. Question 12. The review process indicates a Virginia resident who currently holds a valid concealed handgun permit issued by the state of North Carolina, is seeking clarification on whether their North Carolina permit is sufficient for carrying a concealed handgun within Virginia without needing a Virginia-issued permit. What is the most appropriate course of action to ensure compliance with Virginia's concealed handgun laws? Option A suggests that the individual research online forums and unofficial legal blogs to find discussions and opinions on Virginia's recognition of North Carolina permits. Option B recommend that the individual apply for a Virginia concealed handgun permit immediately, as holding an out-of-state permit may create complications or be insufficient for carrying in Virginia. Option C advise the individual to consult the official Virginia State Police website or contact them directly to confirm Virginia's reciprocity agreements with North Carolina and any specific requirements for non-resident permit holders. Option D inform the individual that since North Carolina is a neighboring state, their permit is almost certainly recognized in Virginia for concealed carry purposes. The correct answer is C. Advise the individual to consult the official Virginia State Police website or contact them directly to confirm Virginia's reciprocity agreements with North Carolina and any specific requirements for non-resident permit holders. Explanation: the review process indicates a scenario where a Virginia resident who has obtained a concealed handgun permit from another state is seeking to understand the implications for their Virginia permit. This situation is professionally challenging because it requires a nuanced understanding of Virginia's reciprocity laws and the specific requirements for non-resident permits, as well as the potential for confusion regarding the validity and recognition of permits across state lines. Careful judgment is required to provide accurate guidance that upholds Virginia law and ensures the individual's compliance. The best professional approach involves advising the individual to consult the official Virginia State Police website or directly contact the Virginia State Police for the most current and authoritative information regarding the recognition of out-of-state permits and the requirements for maintaining a valid concealed handgun permit in Virginia. This approach is correct because Virginia law, specifically the Code of Virginia, governs the issuance and recognition of concealed handgun permits within the Commonwealth. The Virginia State Police are the designated authority responsible for administering these laws. Relying on official sources ensures that the advice provided is compliant with current statutes and regulations, preventing potential legal issues for the permit holder. This also acknowledges that reciprocity agreements can change, and direct consultation with the issuing authority is the most reliable method for obtaining up-to-date information. An incorrect approach would be to assume that an out-of-state permit automatically grants the same rights and privileges as a Virginia-issued permit, without verifying specific reciprocity agreements or requirements. This could lead to a misunderstanding of Virginia's laws regarding concealed carry for non-residents, potentially resulting in violations. Another incorrect approach would be to rely on informal advice from friends, online forums, or non-official sources. Such information may be outdated, inaccurate, or misinterpreted, and does not carry the weight of official guidance. This failure to seek authoritative information poses a significant regulatory risk. Professionals should employ a decision-making framework that prioritizes accuracy and compliance with governing laws. This involves identifying the relevant jurisdiction, Virginia, understanding the specific legal question, recognition of out-of-state permits, and directing the individual to the primary source of legal authority for that jurisdiction. When in doubt, or when dealing with matters of legal compliance, always err on the side of caution and seek official confirmation. Question 13. Examination of the data shows that a resident of North Carolina who holds a valid concealed handgun permit issued by their home state is applying for a Virginia non-resident concealed handgun permit. The applicant has heard from a friend that as long as they have a permit from North Carolina, Virginia will automatically recognize it without any additional steps. What is the best course of action for this applicant to ensure a successful and compliant application process in Virginia? Option A. Contact the Virginia State Police directly or consult the official Virginia Code and the Virginia State Police website for specific requirements regarding non-resident concealed handgun permits and reciprocity with North Carolina. Option B. Assume that since North Carolina issues concealed handgun permits, Virginia will have a reciprocal agreement that requires no further action on their part beyond holding their home state permit. Option C. Rely on the information provided by their friend, assuming that a valid North Carolina permit is sufficient for automatic recognition by Virginia. Option D. Submit the application with only their North Carolina permit information, assuming Virginia's reciprocity laws will automatically grant them a non-resident permit. The correct answer is A. Contact the Virginia State Police directly or consult the official Virginia Code and the Virginia State Police website for specific requirements regarding non-resident concealed handgun permits and reciprocity with North Carolina. Explanation: this scenario presents a professional challenge because it requires a Virginia non-resident concealed handgun permit applicant to navigate potentially conflicting information regarding their home state's permit status and Virginia's reciprocity requirements. The applicant's misunderstanding of the reciprocity agreement's limitations could lead to an incomplete or inaccurate application, potentially resulting in denial or, worse, carrying a concealed handgun without a valid permit under Virginia law. Careful judgment is required to ensure the applicant provides all necessary and accurate documentation as mandated by the Virginia State Police. The best professional approach involves the applicant proactively seeking clarification directly from the Virginia State Police or consulting the official Virginia Code regarding concealed handgun permits and reciprocity. This ensures they are working with the most accurate and up-to-date information directly from the governing authority. This approach is correct because Virginia Code Section 18.2-308.02 outlines the requirements for obtaining a non-resident permit, including the necessity of holding a valid concealed handgun permit in their home state. Furthermore, Virginia's reciprocity agreements, as detailed by the Virginia State Police, are specific and require adherence to the terms outlined. By directly contacting the state police or consulting the official code, the applicant ensures they understand the precise conditions under which Virginia recognizes permits from other states and what documentation is required for their specific situation, thereby fulfilling the statutory requirements for a non-resident permit. An incorrect approach involves the applicant relying solely on informal advice from a friend or an online forum. This is professionally unacceptable because such sources may not be current, accurate, or specific to Virginia's legal requirements. The Virginia State Police are the definitive source for permit information, and relying on hearsay can lead to misinterpretations of reciprocity laws and application procedures, potentially violating Virginia Code Section 18.2-308.02. Another incorrect approach is for the applicant to assume that because their home state has a concealed handgun permit, Virginia will automatically recognize it without further verification or specific documentation. This is professionally unacceptable as it ignores the explicit requirements for non-resident permits and the nuances of reciprocity agreements. Virginia's recognition of out-of-state permits is conditional and requires the applicant to demonstrate compliance with Virginia's specific criteria, as outlined by the Virginia State Police. Failure to do so constitutes a violation of the application process. The professional reasoning process for such situations involves prioritizing official sources of information, understanding that legal and regulatory requirements are precise, and proactively seeking clarification when uncertainty exists. Professionals should always verify information against the governing statutes and regulatory bodies to ensure compliance and avoid potential legal ramification. Question 14. Upon reviewing a Virginia resident's request for guidance on obtaining a non-resident concealed handgun permit for use in Virginia, what is the most appropriate course of action to ensure compliance with Virginia law? Option A. Inform the applicant that since they hold a valid concealed handgun permit from their home state, it is likely recognized in Virginia due to reciprocity, and they should simply carry their permit and identification. Option B. Recommend that the applicant research general concealed carry laws for Virginia online and submit any application that appears to be for a concealed handgun permit, assuming the process will be straightforward. Option C. Suggest the applicant contact their home state's law enforcement agency to inquire about how their permit might be honored in Virginia, as their home state would be the primary source of information. Option D. Advise the applicant to consult the Virginia State Police or the relevant issuing authority to obtain the official application and verify all specific requirements for non-resident permits, including any necessary training or documentation, and to confirm reciprocity status with their home state. Correct answer is D. Advise the applicant to consult the Virginia State Police or the relevant issuing authority to obtain the official application and verify all specific requirements for non-resident permits, including any necessary training or documentation, and to confirm reciprocity status with their home state. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a Virginia resident applying for a non-resident concealed handgun permit to navigate the specific requirements of a state where they do not reside. The applicant must accurately understand and comply with Virginia's laws regarding reciprocity and the conditions under which a non-resident permit can be obtained, even if they hold a valid permit from their home state. Misinterpreting these requirements can lead to denial of the application, potential legal issues, and a failure to uphold professional diligence in advising the applicant. Correct approach analysis. The best professional practice involves thoroughly researching and understanding Virginia's specific statutory requirements for non-resident concealed handgun permits, as outlined in the Code of Virginia. This includes verifying if Virginia has a reciprocity agreement with the applicant's home state and confirming that the applicant meets all eligibility criteria, such as age, residency, and any specific training requirements mandated by Virginia for non-residents. The correct approach is to advise the applicant to directly consult the Virginia State Police or the relevant issuing authority to obtain the most current and accurate application forms and instructions, ensuring all documentation is complete and submitted according to Virginia's legal framework. This approach prioritizes adherence to the specific laws of Virginia, which is paramount for a non-resident permit application. Incorrect approaches analysis. Advising the applicant to assume that their home state permit automatically grants them the same rights in Virginia without verifying specific non-resident provisions is a significant regulatory failure. Virginia law dictates the process for non-residents, and assuming reciprocity without confirmation can lead to a violation of Virginia's concealed handgun permit laws. Relying solely on general information about concealed carry laws without confirming Virginia's specific statutes for non-residents is also an ethical and regulatory lapse. Furthermore, suggesting the applicant can simply present their home state permit at a Virginia law enforcement agency without a formal application process for a non-resident permit misunderstands the legal distinction between carrying under reciprocity and obtaining a specific non-resident permit. This approach fails to acknowledge Virginia's procedural requirements for non-residents. Professional reasoning. Professionals should adopt a systematic approach when advising clients on matters involving interjurisdictional legal compliance. This involves 1. Identifying the specific jurisdiction whose laws are in question, Virginia in this case. 2. Ascertaining the client's status within that jurisdiction, non-resident. 3. Researching the precise statutory requirements for that status within the relevant jurisdiction's legal code. 4. Verifying any applicable reciprocity agreements or specific application procedures. 5. Directing the client to the official issuing authority for the most accurate and up-to-date information and forms. This structured process ensures that advice is legally sound, ethically responsible, and tailored to the specific circumstances and jurisdictions involved. Question 15. When evaluating the legal implications of carrying a concealed handgun in another state with a Virginia non-resident concealed handgun permit, what is the most prudent and legally sound course of action for the permit holder? Option A. Rely on advice from fellow gun owners or online forums to understand the laws of the destination state. Option B. Carry the firearm according to Virginia's laws, believing the permit overrides the laws of the visited state. Option C. Assume that the Virginia non-resident concealed handgun permit grants the same carrying privileges in all other states. Option D. Proactively research the specific concealed carry laws of the destination state, including reciprocity agreements with Virginia and any local restrictions, utilizing official government sources. The correct answer is D. Proactively research the specific concealed carry laws of the destination state, including reciprocity agreements with Virginia and any local restrictions, utilizing official government sources. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a Virginia concealed handgun permit holder to navigate the nuances of interstate reciprocity and understand the specific legal requirements of another state when carrying a firearm. Misunderstanding or misapplying these laws can lead to severe legal consequences, including arrest, fines, and loss of permit privileges. The core challenge lies in ensuring compliance with the laws of the jurisdiction where the individual is temporarily present, even if those laws differ from their home state's regulations. Correct approach analysis. The best professional practice involves proactively researching and understanding the concealed carry laws of any state the permit holder intends to visit. This includes verifying if Virginia's permit is recognized in that state, understanding any specific restrictions or requirements, such as signage, magazine capacity limits, or prohibited locations, and ensuring adherence to those rules. This approach is correct because it prioritizes legal compliance and safety by obtaining accurate information directly from reliable sources, such as the official government websites of the destination state or their Attorney General's office. This proactive research directly aligns with the ethical responsibility of a permit holder to carry firearms lawfully and responsibly in all jurisdictions. Incorrect approach is analysis. One incorrect approach is assuming that a Virginia concealed handgun permit is automatically recognized with the same privileges in all other states. This assumption is dangerous and legally flawed, as reciprocity agreements vary significantly between states. Relying on this assumption can lead to unknowingly violating another state's laws. Another incorrect approach is to only rely on informal advice from friends or online forums regarding another state's gun laws. While these sources may sometimes offer accurate information, they are not official or legally binding. Laws can change, and informal advice may be outdated, misinterpreted, or simply incorrect, leading to potential legal entanglements. A further incorrect approach is to disregard the laws of the visited state entirely, believing that the Virginia permit supersedes them. This demonstrates a profound misunderstanding of jurisdictional authority and the principle that individuals are subject to the laws of the place they are physically located. This approach is not only illegal but also ethically irresponsible, as it disregards the safety and legal framework established by the host state. Professional reasoning. Professionals should adopt a decision-making framework that emphasizes due diligence and a commitment to lawful conduct. When traveling to another jurisdiction, the primary steps should be: 1. Identify the destination state's. 2. Consult official government resources of the destination state to determine reciprocity with Virginia's concealed handgun permit and understand any specific carry laws or restrictions. 3. If unsure, contact the relevant law enforcement agency or Attorney General's office in the destination state for clarification. 4. Always err on the side of caution and adhere to the strictest interpretation of the laws if there is any ambiguity. Question 16. The analysis reveals that a Virginia resident who possesses a valid Virginia concealed handgun permit is planning a trip to North Carolina and intends to carry their concealed handgun. What is the most prudent course of action to ensure legal compliance while carrying in North Carolina? Option A. Research North Carolina's laws regarding concealed handgun carry for non-residents and confirm if Virginia permits are recognized, while also understanding any specific restrictions on where firearms can be carried in North Carolina. Option B. Assume that a valid Virginia concealed handgun permit allows for concealed carry in North Carolina without further investigation, as most states have reciprocal agreements. Option C. Rely solely on Virginia's concealed handgun laws, as the permit was issued by Virginia and therefore should be valid everywhere. Option D. Seek advice from friends who have carried firearms in North Carolina and follow their recommendations. The correct answer is A. Research North Carolina's laws regarding concealed handgun carry for non-residents and confirm if Virginia permits are recognized, while also understanding any specific restrictions on where firearms can be carried in North Carolina. Explanation. The analysis reveals a scenario where a Virginia resident, holding a valid Virginia concealed handgun permit, is seeking to carry a concealed handgun in North Carolina. The situation presents a professional challenge because it requires understanding and adhering to the reciprocity laws between Virginia and North Carolina regarding concealed handgun permits. Misinterpreting or failing to ascertain the correct legal framework can lead to serious legal consequences, including criminal charges. Careful judgment is required to ensure compliance with the laws of the state where the individual intends to carry the concealed handgun. The best professional approach involves proactively researching and confirming North Carolina's laws on concealed handgun carry for non-residents who hold permits from other states. This includes verifying if North Carolina recognizes Virginia concealed handgun permits and under what specific conditions. This approach is correct because Virginia's concealed handgun permit holders are only permitted to carry concealed handguns in other states if those states have reciprocity agreements with Virginia, or if the individual otherwise meets the legal requirements for carrying a concealed handgun in that state. North Carolina does have reciprocity with Virginia, meaning a valid Virginia concealed handgun permit is recognized. However, the permit holder must still abide by all North Carolina laws regarding the carrying of concealed handguns, including restrictions on where firearms can be carried, e.g., schools, courthouses. An incorrect approach would be to assume that a valid permit from one state automatically grants the right to carry concealed in all other states. This assumption is flawed because firearm laws are state-specific, and reciprocity is not universal. Relying on such an assumption would violate North Carolina law if the permit holder were to carry in a location prohibited by North Carolina statutes, even with a valid Virginia permit. Another incorrect approach would be to only consult Virginia's laws regarding concealed carry. While understanding Virginia's requirements is essential for maintaining a permit, it does not provide the necessary information to legally carry in another state. The laws of the jurisdiction where the individual intends to carry are paramount. A further incorrect approach would be to rely on informal advice from friends or online forums without verifying the information through official sources. Such sources may be outdated, inaccurate, or misinterpret complex legal nuances, leading to unintentional violations. Professionals should adopt a decision-making framework that prioritizes due diligence and adherence to the laws of the relevant jurisdiction. This involves 1. Identifying the jurisdiction where the activity will take place. 2. Researching the specific laws and regulations of that jurisdiction pertaining to the activity, in this case, concealed handgun carry for non-residents. 3. Consulting official government websites or legal resources for accurate and up-to-date information. 4. Understanding any reciprocity agreements or lack thereof. 5. Acting in accordance with all applicable laws and regulations. Question 17. Comparative studies suggest that individuals seeking to carry concealed handguns in states other than their primary residence must navigate complex legal landscapes. A Virginia resident holding a valid Virginia concealed handgun permit wishes to obtain a non-resident concealed handgun permit in North Carolina. Which of the following approaches best ensures compliance with North Carolina law and ethical practice? Option A. Rely on general knowledge of concealed carry laws and submit an application to North Carolina without verifying the specific requirements for non-residents, assuming commonalities with other states. Option B. Apply for North Carolina concealed handgun permit by submitting a copy of their Virginia permit and stating they are a Virginia resident, expecting the process to be identical to obtaining a permit in Virginia. Option C. Thoroughly research North Carolina's specific statutes and administrative rules regarding non-resident concealed handgun permits, including eligibility criteria, required training, and the application process, and submit an application that fully complies with these requirements. Option D. Assume that the Virginia concealed handgun permit is sufficient for concealed carry in North Carolina due to reciprocity agreements, and proceed with carrying concealed without obtaining a separate North Carolina permit. The correct answer is C. Thoroughly research North Carolina's specific statutes and administrative rules regarding non-resident concealed handgun permits, including eligibility criteria, required training, and the application process, and submit an application that fully complies with these requirements. Explanation. Scenario analysis. This scenario presents a professional challenge for a Virginia resident applying for a non-resident concealed handgun permit in another state. The core difficulty lies in navigating the reciprocity and permit requirements of a jurisdiction where the applicant is not a resident, potentially encountering differing legal standards, application processes, and background check procedures. Careful judgment is required to ensure full compliance with the laws of the state where the permit is sought, as well as understanding how this might impact their Virginia permit status or future applications. Correct approach analysis. The best professional practice involves proactively researching and adhering to the specific concealed handgun permit laws and application procedures of the state where the non-resident permit is being sought. This includes understanding that states' eligibility requirements, training mandates, background check processes, and any specific provisions for non-residents. This approach is correct because Virginia's concealed handgun permit laws, while governing residents, do not dictate the requirements for obtaining a permit in another state. Each state has its own statutory framework for issuing permits, and a Virginia resident must satisfy those specific requirements to be legally permitted to carry concealed in that other state. Failure to do so could result in violations of that state's laws. Incorrect approach is analysis. Pursuing a non-resident permit by solely relying on the applicant's existing Virginia concealed handgun permit, without verifying the other state's specific requirements, is professionally unacceptable. This approach fails to acknowledge that a Virginia permit does not automatically grant concealed carry privileges in another state, nor does it exempt the applicant from that state's unique application and eligibility criteria. Another incorrect approach is assuming that the application process in the other state will mirror Virginia's, leading to potential omissions or misrepresentations on the application. This disregard for the distinct legal landscape of the destination state constitutes a significant regulatory failure. Finally, attempting to obtain a non-resident permit without completing any required training or background checks mandated by the destination state is a direct violation of that state's laws and poses a serious ethical and legal risk. Professional reasoning. Professionals in this situation should employ a systematic decision-making process. First, identify the specific state in which the non-resident permit is desired. Second, thoroughly research that state statutes and administrative regulations pertaining to concealed handgun permits, paying close attention to provisions for non-residents. Third, meticulously follow all application instructions, including any required documentation, fees, training certifications, and background check authorizations. Fourth, be prepared for potential differences in requirements compared to one's home state, and seek clarification from the issuing authority if any aspect of the process is unclear. Question 18. The investigation demonstrates that an applicant for a Virginia non-resident concealed handgun permit disclosed a prior arrest for a misdemeanor offense that was later dismissed. Considering Virginia's regulatory framework for concealed handgun permits, which of the following represents the most appropriate course of action for the licensing authority? Option A. Ignore the dismissed charge as it is not a conviction and therefore has no bearing on the applicant's eligibility for a concealed handgun permit in Virginia. Option B. Automatically approve the permit application because the misdemeanor charge was dismissed, as a dismissal negates any potential disqualification. Option C. Conduct a thorough review of the applicant's entire criminal history, including the dismissed charge, to determine if the underlying conduct associated with the dismissed charge disqualifies the applicant under Virginia Code Section 18.2-308.09 and assess the applicant's disclosure for completeness and accuracy. Option D. Deny the permit application solely based on the existence of a prior arrest, without further investigation into the nature of the dismissed charge. The correct answer is C. Conduct a thorough review of the applicant's entire criminal history, including the dismissed charge, to determine if the underlying conduct associated with the dismissed charge disqualifies the applicant under Virginia Code Section 18.2-308.09 and assess the applicant's disclosure for completeness and accuracy. Explanation. The investigation demonstrates a scenario where an individual seeking a Virginia non-resident concealed handgun permit has a prior arrest for a misdemeanor offense that was subsequently dismissed. This situation is professionally challenging because it requires a nuanced understanding of Virginia's eligibility criteria for concealed handgun permits, specifically how prior arrests, even those that did not result in a conviction, can impact an applicant's suitability. The applicant's honesty and completeness in disclosing this information are paramount, as is the licensing authority's thorough and accurate assessment of the applicant's history against the statutory requirements. The best professional practice involves a comprehensive review of the applicant's entire criminal history, including the dismissed charge, and a determination of whether that specific charge, even without a conviction, disqualifies the applicant under Virginia law. This approach is correct because Virginia Code Section 18.2-308.09 outlines the grounds for denying a concealed handgun permit, which includes certain disqualifying offenses. While a dismissal may seem to negate a conviction, the licensing authority must still assess if the underlying conduct associated with the dismissed charge falls within any of the statutory disqualifiers, such as those related to domestic violence or certain violent misdemeanors, even if the charge itself was not prosecuted to conviction. The applicant's disclosure of the arrest and dismissal coupled with the licensing authority's diligent investigation into the nature of the dismissed charge, ensures compliance with the spirit and letter of Virginia law, which prioritizes public safety. An incorrect approach would be to automatically approve the permit solely because the charge was dismissed. This fails to acknowledge that Virginia law may consider the circumstances of a dismissed charge in determining eligibility, particularly if the underlying conduct would have been disqualifying. Another incorrect approach is to deny the permit without a thorough investigation into the specifics of the dismissed charge, relying only on the fact of an arrest. This could lead to an arbitrary denial and a failure to adhere to the due process afforded to applicants. Finally, an incorrect approach would be to ignore the dismissed charge altogether, assuming it has no bearing on the permit application. This neglects the licensing authority's duty to conduct a complete background check and assess all relevant information against the statutory requirements. Professionals should employ a decision-making framework that begins with a thorough review of the application and all supporting documentation. This includes verifying the applicant's statements and conducting a comprehensive background check. When discrepancies or potentially disqualifying information, such as a dismissed arrest, are identified, the next step is to investigate the specifics of that information. This involves understanding the nature of the charge, the circumstances surrounding the arrest, and the legal basis for the dismissal. This information is then compared against the specific disqualifying criteria outlined in Virginia Code Section 18.2-308.09. If the dismissed charge, based on its underlying conduct, does not meet any disqualifying criteria, the permit may be issued. If it does, the permit must be denied, with proper notification to the applicant. This systematic and evidence-based approach ensures fairness, accuracy, and adherence to Virginia's concealed handgun permit regulations. Question 19. Analysis of a scenario where a licensed firearms dealer in Virginia is presented with a handgun purchase by an individual claiming to be a resident of North Carolina who possesses a North Carolina concealed handgun permit. What is the best practice for the Virginia dealer to ensure compliance with Virginia's laws regarding non-resident concealed handgun permits? Option A. The dealer should only require the individual to pass the federal background check, as this is the primary federal requirement for firearm sales. Option B. The dealer should verify that the North Carolina concealed handgun permit is currently valid and that Virginia law recognizes it for the purpose of purchasing a handgun. Option C. The dealer should accept the North Carolina concealed handgun permit at face value, assuming it is valid and recognized by Virginia for all firearm transactions. Option D. The dealer should proceed with the sale if the individual has a valid North Carolina driver's license, as this indicates legitimate residency and intent. The correct answer is B. The dealer should verify that the North Carolina concealed handgun permit is currently valid and that Virginia law recognizes it for the purpose of purchasing a handgun. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a Virginia licensed firearms dealer to navigate the complexities of interstate handgun sales while adhering strictly to Virginia's concealed handgun permit laws and federal regulations. The dealer must ensure compliance with both state and federal requirements to avoid legal repercussions and maintain ethical business practices. The core challenge lies in verifying the legitimacy of a non-resident's ability to purchase a handgun for concealed carry in Virginia, which involves understanding the nuances of reciprocity and permit validity. Correct approach analysis. The best professional practice involves the dealer meticulously verifying the non-resident applicant's valid concealed handgun permit from their home state, ensuring that this permit is recognized as valid in Virginia for the purpose of purchasing a handgun. This approach is correct because Virginia law, specifically the Code of Virginia Section 18.2-308.02, addresses the recognition of concealed handgun permits from other states. A dealer must confirm that the applicant's out-of-state permit is currently valid and that Virginia law permits its recognition for handgun purchases. This proactive verification ensures that the transaction complies with both federal firearm transfer laws, like the National Instant Criminal Background Check System (NICS), and Virginia's specific requirements for non-residents purchasing handguns for concealed carry. It prioritizes legal compliance and responsible firearm sales. Incorrect approaches analysis. One incorrect approach involves accepting the non-resident's word that they possess a valid concealed handgun permit from their home state without independent verification. This is ethically and legally flawed because it bypasses the dealer's responsibility to ensure compliance with Virginia law. The dealer cannot assume the permit is valid or recognized by Virginia. Another incorrect approach is to assume that any concealed handgun permit from another state automatically allows for a handgun purchase in Virginia. This is incorrect because Virginia law may have specific reciprocity agreements or limitations on which out-of-state permits are recognized for handgun purchases, not just for carrying. The dealer must confirm the specific validity and recognition of the permit for the intended purpose. A further incorrect approach is to proceed with the sale based solely on the applicant's Virginia residency status, disregarding the need for a valid, recognized concealed handgun permit for non-residents. This fails to address the specific requirements for non-residents wishing to purchase handguns for concealed carry in Virginia, as outlined in the relevant statutes. Professional reasoning. Professionals in this situation should adopt a systematic verification process. This involves 1. Confirming the applicant's identity and residency. 2. Requesting proof of a valid concealed handgun permit from their home state. 3. Independently verifying, through official Virginia resources or established legal guidance, that the applicant's home state permit is recognized by Virginia for handgun purchases. 4. Completing all required federal background checks. This layered approach ensures adherence to all applicable laws and ethical obligations. Question 20. Consider a scenario where an applicant for a Virginia non-resident concealed handgun permit has recently been awarded $50,000 in damages from a civil lawsuit. The applicant's legal representation has informed them that the total legal fees and court costs associated with this case will amount to $15,000. What is the accurate net financial impact of this legal judgment that should be reported on the permit application? Option A. Approximately $30,000 to $40,000. Option B, $15,000. Option C, $35,000. Option D, $50,000. The correct answer is C, $35,000. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the applicant to accurately calculate and report financial information for a Virginia non-resident concealed handgun permit application, specifically concerning the financial impact of a recent legal judgment. Misrepresenting or inaccurately calculating this information can lead to permit denial, and in some cases, legal repercussions. The applicant's understanding of Virginia's specific financial disclosure requirements for permit applications is paramount. Correct approach analysis. The best professional practice involves accurately calculating the net financial impact of the legal judgment by subtracting the total anticipated legal fees and court costs from the awarded damages. This approach directly addresses the requirement to disclose the applicant's current financial standing as it pertains to the legal judgment. The calculation should be presented clearly, showing the gross award and the deductions, resulting in a net figure. This aligns with the principle of providing truthful and accurate information on official applications, as mandated by Virginia law for concealed handgun permits, which requires applicants to be of good character and not have been convicted of certain offenses or be subject to certain legal restraints that would indicate a propensity for violence or an inability to handle a firearm responsibly. Financial stability, as impacted by significant legal judgments, can be a factor in this assessment. The formula for this calculation is net award equals gross damages, legal fees plus court costs. Incorrect approaches analysis. One incorrect approach involves simply reporting the gross damages awarded without accounting for the significant legal fees and court costs. This misrepresents the applicant's actual financial gain from the judgment, potentially creating a misleading impression of their financial stability or resources. This failure to provide a complete and accurate financial picture violates the spirit and letter of the application's disclosure requirements. Another incorrect approach is to report only the anticipated legal fees and court costs, omitting the gross damages awarded. This is equally misleading, as it focuses solely on the expenses without acknowledging the compensatory award, again distorting the applicant's true financial position relative to the judgment. A third incorrect approach is to estimate the net award without performing a precise calculation, perhaps by rounding figures or making assumptions about future costs. This lack of precision and reliance on estimation, rather than exact figures, fails to meet the standard of accuracy required for official applications and could be interpreted as an attempt to obscure the true financial outcome. Professional reasoning. Professionals should approach such applications with a commitment to absolute accuracy and transparency. The decision-making process should involve 1. Thoroughly understanding the specific disclosure requirements of the Virginia non-resident concealed handgun permit application, particularly regarding financial matters and legal judgments. 2. Identifying all relevant financial figures, the gross damages awarded, and all associated legal fees and court costs. 3. Performing precise calculations to determine the net financial impact. 4. Clearly documenting the calculation process and the final net figure on the application. 5. Consulting with legal counsel if there is any ambiguity regarding the financial disclosures or their implications for permit eligibility.